They have completed their. This is the Innoco's order class, Mrs. Rahul Kumar.
Because pursuant thereto, they have asked a reason order.
But then, if you are agreed to challenge it in a writ application, how a contempt is maintained?
Because the reconsideration was there on two counts.
See?
One, they had to consider 2012 circuit.
By filing this present contempt, the petitioner alleges violation of the order passed by the division bench headed by the then Chief Justice of this court in LP number 663-2018 on 23rd of January 2019. So, it appears from the order that a Innoco's order was passed, direction was given. Innoco's direction was given for considering the case of the petitioner by the officials of the Central Coalfield Limited. So, they have reconsidered the matter and has rejected the application of the petitioner. So, in that view of the matter, we are of the opinion that a contempt application will not lie. So, if the petitioner has any further grievance arising out of the order passed, that is Annexure 2.
Annexure 4, yes.
There is Annexure 4. Then he is at liberty to file a fresh writ application, if so advised. If such observation, the contempt is dropped. Civil contempt is dropped. थोड़ा टाइम लगेगा Yes.
Item number 2, WPC 4748 of 22.
The petitioner is seeking for price escalation, which in the contract awarded to it, the few dates would be relevant. The 11/7/2019, the bids were.
There is no arbitration clause.
There is no arbitration clause. If management turn to page 100, that's the cause of action. And I am writing to them that I am not at fault. It is because you did not provide me the land and I had to do certain additional work. That is why I had created it. It is their own letter, which is more of an admission. May I please please?
You have any instructions? You take instructions. Let the land council for the state take instructions in matter and apprise the court if there is any admitted dues of the petition.
No, it's not. This is a case of price escalation.
If there is any ground for price escalation as per the tender awarded to him, matter will be listed on 4th of October in the same heading. Press behind. You don't have to file a counter affidavit. We'll see that.
Item number 3, Contempt 6 of 23.
Last visit manager, Mr. was part to seek instruction regarding compliance of the order. Yesterday, we have received a proposal in 11/9/23. We intend to file our reply to that, but on the basis of it, the proposal will demonstrate the effort of the party member to abolish the order.
What is the instructions here?
My lord, we have the estate has gone to high court, and my lord, due to pendency, my lord, we have estate the proceeding of the proceeding. So, my lord, the suit is pending. They have already appeared, filed the written statement. Let the matter be decided by the competent civil court. What is wrong in this proposal, my lord, I request the point of view.
If I make my submission,
The application appellant will appeal in the circuit. Date of receipt of application.
if I refer my
Again, it is a no-cost order.
my no, it
What is the mandamus?
was the main order, the enforcement proceeding order that was initiated, that has been paused and subsequently matter was referred before the authority concerned.
Director, the circle officer decides director to revive the proceeding.
Para 9 में
और वो revive नहीं हुआ है.
Now,
We have a state record. We are not proceeding because we have preferred to file suit. Suit report is competent civil.
no, two,
नहीं, whether the circle officer has restored the file or not. इसमें उसमें लिखा है ना, the CEO is director to revive the proceeding pertaining to encroachment of a fee. That is a mandamus, and then decide the matter. If he doesn't decide, then it will contempt will lie. If he decides in one way or the other, then it will contempt will lie.
Decision will not decision. That is the decision will not. That we will not proceed. We will not be title to be decided. The decision will not that encroachment will be required on the.
But that is the direction of the division bench to decide the
So,
matter.
so we have decided that we are not proceeding with the encroachment case. Team will not this to be decided.
Have you revived the encroachment case?
Because that is.
See, the procedure would be you have to revive the encroachment case, then pass an order in the encroachment case.
Yes,
then
order has
proceed.
passed.
We will not proceed in view of the title suit.
Yes.
Have you done that?
Order we have order has passed. CEO has passed the order that we will not proceed. That is
Okay,
only up to you.
let the CEO remain present on the next day for framing of charges.
Review of charges, you also will not take a view, but proceeding will not, there is a question of proceeding, if we are taking a step, the order has been passed, that we will not proceed, till the title should be decided.
But that is nullified by necessary implication of by this division bench order.
As much to take a decision, we have taken a decision not to proceed. Encroachment case will not proceed, because after order of this honorable court, we have decided to prefer a suit for deciding, because it appears to be a dispute title. So where is the question? We are, and the petitioner has not,
if I make a small submission, now what is happening? The encroachment proceeding is there. He says I have stayed it, and a suit has been filed, which is 158 of the CNT. There is a 87. Now I'm making my submission a step ahead. Suppose tomorrow the suit is decided to the best in the favor of state, whether the decree will be executed in the encroachment proceeding. The encroachment proceeding, the title of the estate itself is under crown, therefore they have to approach the civil court for declaration of their right title and recovery of possession. That is their suit. Now keeping the encroachment case pending parallelly for the same purpose, now whether a decree is passed,
actually will not they want.
But it's not opening.
It is open. And now 11 main court. पूरा segregate कर दिया. पूरा step by step.
Yes. Let a feel of this.
State has filed the suit.
Estate. And you will see the order we have closed of the encroachment case. Now, actually, the petitioner want us not to proceed with the suit. That is now in the garb of this contempt petition that is presiding over the attempt of the petitioner. So, we are subject to all of this suit, whether the encroachment case will lie, not lie, but that will be decided that the approval is safe. But so far, the contempt
The civil suit has been filed after passing of this
after
order.
passing of this order. Because crime assignment that get personal, that it is a matter of a dispute of right. So, they were approached.
VP आगे दीजिए तो झारखंड पब्लिक लैंड एनक्रोचमेंट एक्ट.
My submission was made, it is not a public land, since they have now come before the civil court for declaration of their title and recovery of possession. Now, a decree, even assuming the best case of the other side, a decree is in favor of the state. Whether they will go for execution or they will then attach the decree before the circle officer and proceed with the encroachment. We had before the first instance, we were before the court for that the maintainability of the encroachment proceeding we had challenged. Now, my lord, 87.
Yeah, but when there is a dispute,
My lord,
admittedly there is a dispute because the state government has filed a civil suit.
that, yes.
The district administration has filed a civil suit. Now, if there is a civil suit where the question whether it will be it is a public land or a private land is to be decided, how the encroachment will proceed?
That is what I am saying. Encroachment is.
That's why we
So
were
encroachment. So that is what my submission. My again I am making slowly my submission.
तो आपका कहना क्या है?
मेरा कहना है कि encroachment केस का अब तो चलने का कोई मतलब नहीं है. It is a parallel proceeding. यदि सूट में इनका डिक्री हो जाएगा, he has prayed for declaration.
But how can you ask for a quashing of the proceeding in a contempt application?
No. That is the purpose. How they are trying to overreach the order. And second submission is matter. They kindly have looked to section 258 of the CNG.
Just answer. You have prayed for a contempt to initiate a contempt.
Yes.
Which order they have violated? What do
Yes.
you want?
This
You want the
order-
contempt? You want the encroachment proceeding to continue?
No, encroachment proceeding
What do you
to be
want?
decided finally. They have said that
you,
stayed
so you want that the encroachment proceeding to continue?
to continue and to be decided by.
So they have filed a civil suit.
Yes. Which is not maintainable in terms of section 254
That
of the
is
CNG.
that you go
So
and
this
file
is
a order
my
7 rule
submission.
11. Mr. Counsel, you go and file order 7 rule 11 there.
If you say that it is not maintainable, you can always raise a preliminary issue, 711 petition file कीजिए, and then a order will be passed by the civil court. And then after the order is passed, you can revision encroachment case will proceed.
My lord, my small submission was 711 that we have done it. We have appeared, we have appealed. My only submission is when suit is filed, when the title of the estate itself is included, whether keeping that proceeding is came, public land encroachment proceeding, when the public land declaration itself is a summary proceeding, tomorrow if the suit is decided, I am putting a question, and the state wins, what will be the fate applying of that encroachment proceeding? Whether this decree will help them in proceeding with the encroachment or decree will go for execution?
That
Under 21.
they have both the options. They can levy execution and they can also proceed on the profit
In my
premises.
humble submission, in my humble submission, in my understanding, in public land encroachment, because that is no other claim for a pilot, a decree is there, so execution under 21 that is provided and is.
In this
So, it's not my
application for
mandate.
civil contempt, the petitioner asserts that the order passed by the division bench of this court, headed by the then Chief Justice of this court, on on 14 October 2020, in LT number 627 of 2018, has been willfully and deliberately violated. However, it is borne out in the record that the state has already filed a civil suit before the competent civil court, and the question of the land being a public land or a private land is to be adjudicated by the suit. In that view, the matter, the circle officer is not proceeding with the encroachment case bearing number 1 of 2013 has been 14. However, learned counsel for the petitioner will submit that if the suit is decreed in favor of the state, then the then the state may file execution for recovery of the said land, and the encroachment proceedings will not be continued. So we are not in agreement with the submissions made by the land council for the petitioner, as the state has two remedies. If the suit is decreed in its favor, it can proceed under Order 21 of the Code of Civil Procedure 1906, or it may proceed with the encroachment proceeding initiated under the Jharkhand Public Land Encroachment Act 2000. In that view of the matter, we find no willful and deliberate disobedience of the order passed by this court by the respondent container, and the contained application is dropped. That's will be the order 65 urgent certified copy. Order already declared. Please.
One submission
No problem. No.
regarding maintainability, because
Item number
small
4.
submission that will be required. Like we have advised regarding the maintainability
They
of
have
the
already
soil.
filed not their written statement. This plea has not been taken.
7 written we have filed.
Let me decide on this civil
No,
court.
I am not asking for this.
We have passed an order, we have not said anything, we have not taken away any of your rights.
Item number 4, Contempt Civil 361 of 23.
Let's we also may have a look of the last order. Let's was listed on 8th of September. Management will also is granted 4 weeks time for the compliance of it to listed today.
39.
Yes.
आज 13 तारीख है ना?
But on the last occasion, we also said that we will listed after 4 weeks for the compliance. Our recommendations.
You mean to say there is a typographical error in this order?
As per my knowledge,
आपका नोट क्या बोल रहा है? 39 है.
Because afterwards, SLP has been dismissed and we have filed a supplementary so was just soon after the dismissal of SLP, we have closed the matter. We need some time also. And in that respect, supplementary so was has been filed. We are seeking 6 weeks time also for compliance.
Land Council for the state will submit that 6 weeks time will be granted to compliance of the order, violation of which has been challenged in this case. Let it be complied within 6 weeks. Matter will be stayed on 6th of December.
Item number 5 and 3207 of 23.
ये पीडीएफ चला रहे हैं, ये आ गया
हाँ, वहाँ से बंद कर दो, क्यों नहीं सर?
इसको.
हाँ, उसको बंद कीजिए, फिर करना पड़ेगा. इसको बता दीजिए कि पुराना वाला और नाउ यू गोइंग टू क्रोम खोलिए.
वो बनाया हुआ बुक मार्क किया हुआ डायरेक्ट. हाँ डायरेक्ट
क्रोम से डायरेक्ट कर लो.
हाँ ऊपर में बुक मार्क किया हुआ.
झारखंड हाई कोर्ट GHC रिपोर्ट राइट हाँ वो बन जाके तो उसमें सेम ई कोड चाहिए ऊपर में.
let him. आई
वो क्लोज हो गया है फिर से.
Okay, thank you. This is item number 5.
Your Lordship, I am praying for short passing my Lordship. After few cases, will be required, Your Lordship.
Okay, keep full cases possible.
Item number 6, WPC 2051 of 23.
This is the second round of litigation. First round of litigation, the actual was there to dispose of my representation and pass a reason order. This matter with respect to release of the security deposit of rupees, only rupees 2 lakh and 1. The reason order passed by the state government is that, Lordship, since with respect to this tender, when FIR is registered before the ACB, and until the government will get the NOC from the ACB, will not able to return the security. This is the stand taken by the state. However, they have filed a response to it, and the ACB is saying that the investigation is still going on. And the state government has replied that since until we get the NOC from the ACB, we will not able to return the security because all the document is seized by them.
It's correct. That is correct. Even a criminal investigation is taken up with relation to the same work, and the document is received, how can your money be refunded?
My submission would be my loss.
What is your instruction?
Let's we file the reply plus pursuant to plus election, and as per the instruction plus the investigation is still going on. Plus. There are around 520 cases plus 20 matters which were taken up in this particular case plus. And the petitioner's case is one, so it cannot be segregated for separate units. Since investigation already proceeding.
What is the amount?
2 lakh something, 2 lakh 12,000. This is pending.
Have you made this the investigating agency is party?
Yes, yes.
What is the instruction from there?
Yes, on their behalf only we have filed an affidavit dated 11/9/23, and stated that accordingly investigation is still going on.
Cannot give a order.
My submission is only since it is when I have completed my work, my amount has been paid, completion certificate has been issued. It is only with respect to 2 lakh odd amount. The government is not declining my amount. They are saying that we can pay, but since we don't have the documents, so to release that particular security. So with respect to that particular purpose, if the ACB can give the photocopies to the department and on that, if the amount is being because this particular issue is nowhere related to the criminal case.
You are not an accused to the criminal case.
No, in that way, I am not the accused.
Looks written in page 8 paragraph specifically looks the investigation is still going on, and the availability of evidence regarding this involvement cannot be ruled out in between.
So, petitioner is also under investigation.
Let us wait for
Yes,
let's wait for the result of the investigation. It is brought to our notice that in the meantime, the documents relating to case, that is the work executed by the petitioner, has been seized by the Anti-Corruption Bureau. And the petitioner himself is also one of the suspects in that case. So in that view, it is appropriate for us to wait for the finalization of the investigation of the case. Matter will listed 20th of December missing awaiting further instructions.
okay.
Item number 7, WPC 3188 of 2022.
Last year, there was a since 2015. He reached to, and as far as no attention has been
This is the first date.
15 in the due, 325, 523. This period, yes.
नहीं 8 years you kept silent. It should be dismissed for delay and laches.
We were making a recommendation to the for 2018.
By filing this read application, the petitioner has paid for the following review. Step it is borne out from the account that because of external rules about 8 years back, the work was executed on 9th, completed on 9/4/2015, and the rate application has been filed in year 2023. Hence, we are of the opinion that the REIT's petition should be dismissed on the ground of delay in lectures. Rate application is accordingly dismissed, being deferred as merit. There shall be no order system for consent by copy of privilege. अब अगर हम बोल देंगे रेमेडी देने के लिए, तो you will say that the High Court has given me direction. आप your claim is barred by law of limitation. No civil court will entertain your application. नहीं, order dictated will not be.